Hello, everyone. I am super excited to be here with you all virtually today to talk about some of my favorite things. So, there are a bunch of laws related to, the human resources function, and they're important for you all to know as managers. So, I put together a quick guide on some of the high level laws that I think will be important for you as you either embark on your management journey or you continue your career with the company. So let's jump right into it. So why is this important? First of all, I want you all to, listen in on this meeting specifically because people management laws are extremely important, and there's something that you need to keep in mind as you work with people and especially represent the company from a management standpoint. So overall, employers must abide by these laws set in place, and it protects us as employers, and it also protects employees such as yourself. So now, you have the power to impact someone's career, and we want to make sure that we're all utilizing it properly because you have a manager as well. So we all want the knowledge to flow. And so the goal is to provide you with what some of these laws are and why they exist. And the hope is that, you will understand what we discussed and that you'll be able to apply them in your roles. And feel free to reach out to us if there's any questions you have or anything that isn't covered here that you would like more knowledge on. And the third one is, we want the outcome to be your ability to make the right decision concerning lawful activity while you're managing people. And so this is important because, again, you're impacting someone's career. A manager is extremely important in a person's life, even outside of the workplace. So we want to protect our brand as a company, your brand, employee morale, and we want to avoid a competitive disadvantage because, our competitors are likely adhering to these laws as well. So we want to be sure we're sticking ahead. So the legal topics that we'll be discussing today are going to be equal employment opportunities, compensation and benefit related law, health and safety related law. And then in the appendix, I have some information about labor relations and employee contracts and agreements. I will run through those and they'll be in the deck, but please go back to the appendix when you need, but I really want to focus on the top 3, and that's where we'll spend, a lot of our time discussing those. So let's jump into equal opportunity employment. So, the purpose of these laws and rights is to provide everyone with equal employment opportunities, regardless of their race, color, religion, sex, age, disability, or national origin. Now, I put in here as an asterisk that a sex is inclusive of biological sex, gender identity, including your transgender status or sexual orientation. So, we most of us are exposed to social media, so we know there's a lot of controversial things that go on. We will not bring, politics or personal opinions into the workplace. We're going to accept everyone the way that they come in the door, the way that you would want to be accepted. So let's be respectful of others regardless of what they look like and who they are. Some of the relevant acts or practices related to EEO is the Civil Rights Act. So, this was founded back with Martin Luther King Jr., and it makes it illegal for an employer to refuse to hire an individual or discriminate against any individual in any way based on the above identified characteristics. So I won't read them off again, but those are protected under the Civil Rights Act, and then it also limits segregation of employment opportunities based on those same attributes. Meaning, if a role is available to a majority, then it needs to be also available to a minority. So that's the Civil Rights Act, and we will adhere to it. Then we have the Americans with Disability Act. So this protects people with disabilities from being discriminated against in the workplace. And disabilities can look extremely different. So that's one thing I want to call out is, as a manager, disability is not always physical. Sometimes it can be a mental incapability or something that you can't see on the surface. So as managers, I want you all to be extremely cognizant on what a disability is. And if you have any questions, please reach out to us, because we know these situations can be hard to handle on your own without the professional advice. So that's my one call out when it comes to disabilities. And we'll also talk about that on the next slide as well. But then we have affirmative action. It goes hand in hand with the Civil Rights Act. So it focuses on intentional recruiting of underrepresented ethnic and racial groups. And so there's been a lot of recent legal activity about affirmative action. So, if there's anything that you all need to know, or if anything changes regarding our recruitment and hiring strategies, we will definitely announce that, and you can reach out to us then with any follow-up questions. But as of right now, we are participating in affirmative action. We want to make sure that our workforce represents the available work, right? So, and then we have OSHA, which you've seen some of these signs. So it's the Occupational Safety and Health Act. So it mandates employers to provide a safe workplace free from serious recognized hazards and providing employees with safe tools and equipment. So this is, most people associate OSHA with warehouse roles or things of that nature, but since we do mostly have corporate offices, I want to be sure that we are also providing as safe of an environment as possible. So if your equipment, if your chairs or anything of that nature needs attending, please let us know and reach out. OSHA is not only about people that are working in the factory with chemicals or hazardous things. We also want to provide a safe workplace in any environment that we are employing people. And as a manager, you're going to be the first line of contact, or the first point of contact for our employees. So I just want to make sure that we're taking, OSHA extremely serious, and that we're applying it in our work dynamics, providing a safe place for our employees. And so regarding the EEO, we have different types of discrimination types, and a little bit more relevant information on the reasonable accommodations. So disparate treatment, this goes hand in hand with the EEO. So this occurs when individuals in similar situations are treated differently, and the different treatment is based on the individual's race, color, religion, sex, national origin, age, or disability. Same asterisk in regards to sex as on the last slide. That is, however someone chooses to identify, or their sexual activity. Or their sexual orientation. And the accusing party must provide that the employer intended to discriminate against them, meaning they need to have concrete written proof, a way to prove that they were discriminated against. So this is something that we don't want to partake in, but if we should, the employee will have to provide that information. So we need to be extremely cognizant that we are not falling victim of applying this disparate treatment, and keeping ourselves out of trouble when it comes to how we govern people. And so on the flip side of treatment, you have impact. So this occurs when an employer excludes a protected group from employment opportunities. This does not need to have intent proven or clarified. This is an impact or consequence of an action. So this is extremely important for managers as you all make the decisions on what happens in the workplace. There are cases that have been made against employers, and the employees have won because they do not have to show that the company intended. They just have to show that it impacted them. So one of the examples is if we are moving desks in an office and employees have to take a test, and everyone that is a specific race failed that test, and that means that they can no longer have a suitable desk and they have to work in a less desirable place. That would be disparate impact, because in that scenario, there's no hardcore proof that the employer decided to seclude that race, but because they were impacted by the test, that is the proof that they need that they were impacted. So that is something that we want to keep in mind. We don't want to be accused of any of these. So if you have any questions on how you're impacting people or any of the decisions you're making, please reach out to us, and let's make sure that we stay clear. We stay clear of these allegations, and we're doing the right thing by people. And so then we have reasonable accommodations. This means that it is placed upon the employer to, we're obligated to purposefully attempt to accommodate an individual's disability or religion. So again, I talked about it on the last slide, so I won't mention too much on it, but disabilities can look extremely different. So it's important that we try to accommodate people when possible, as long as it's not an inconvenience to the company. It doesn't negatively impact how you or your team are getting their job done. And so why do these matter? Why did we spend so much time going over them? So it's important to know what these types of discriminations are, whether it be direct or indirect, the treatment or the impact. And this allows us to understand what they are, and then hopefully we will not have to encounter them, because, knowledge is power. So now that we know about these things, if you have any specific examples, you can reach out. But it's important as managers that you understand the level of importance the company places on discrimination. So we want to make sure we don't discriminate against anyone. And so some more relevant topics are sexual harassment. So again, if anyone's privy to social media, or if you have been watching the news lately, there's been a lot of campaigns. You have the Me Too campaign. You have a lot of influential people on trial. So these type of things impact laws and politics. So, we will keep an eye on if any new laws come out that we need to adhere to. But overall, sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. We do not condone, approve, or accept any form of sexual harassment. That is from a manager or an employee. So if you or anyone you know is being subjected to this, please speak out. We have equal pay. So equal pay requires that men and women employed by the same entity must be provided equal pay for equal work. So the role doesn't need to be identical, but it needs to be significantly comparable. So, for example, if you are managing two different businesses and one is worth $2 million and the other is worth $20 million, although your title might be the same, the responsibilities within that role might look different. So in that case, a different pay rate or a different pay range would be applicable. However, we want to make sure that if the role is significantly similar, we're paying them the same. And then we have gender equity, which obviously rolls up into equal pay, but it upholds the Equal Pay Act by reviewing several aspects. So again, you're looking at the pay, the seniority. It's things based on factors such as location, performance, tenure. And within gender equity, the two focuses are equity in pay and equity in representation, right? So if you're paying male and female the same amount of money, but your leadership team is only 2% female, that's not realistic, because I can guarantee you your available workforce is not only 2% woman if the roles beneath them, if the roles beneath them have a good split of women, that should flow into leadership. So these are the things that we as a company will continue to monitor, and we want to make sure that we get the qualified people in the seat and that we are not, creating barriers for anyone. And so the last thing is our Equal Employment Opportunity Commission. So they're responsible for enforcing the majority of the EEO laws that we just went over. So their three major responsibilities are investigating and resolving discrimination complaints, gathering information, and issuing guidelines. So why is this important that we know who they are? It's important because we do not want to appear in front of them. So, we must adhere to everything that's currently there so that we avoid any conflict with the law. And then any conflicts with them can result in several negative impacts. So that can be court settlements, impaired brand image. There can be court cases even based on the person outside of the employer, depending on how bad the damage is. So we just want to avoid the EEOC at all costs, but I think it is extremely important to let you all know that there is someone that is looking over these types of cases. So there's a dedicated team that's always willing to review these issues. So we need to make sure we're not appearing in front of them. And then we have compensation and benefit law, which this section is extremely important to managers because you are the first point of contact for employees when it comes to their compensation. They're going to look to their manager to make sure that they're being paid properly because you see what they're doing on a day-to-day basis. So, they always they don't always, but they can come to HR if they have any questions about the role or the pay, especially as we're negotiating on a year-end, mid-year basis. But it's also important that you are in tune with your employees. So we're going to go over some of the laws that go into compensation and benefit. So the purpose of this is to ensure that employers are paying fair wages based on circumstances such as gender and disabilities, etc. Right? So some of the relevant acts are the Fair Labor Standards Act. So this actually formalized the minimum wage for jobs. So most recently, it's still at $7.25, and it made overtime rate mandatory for hours worked more than 40. So this means that any hours over 40, you need to be paid overtime. So different states have different wages. So adhere to your employment state. If you have any questions about that, you can check your state's website, your state's government website, and it will tell you what the minimum wage is, and then it will also be reflected in the pay automatically. But that's something to keep in mind, is doing business in different states has a different minimum wage, and we'll always adhere to that. And then the Equal Pay Act, we've already discussed this on the EEO, but it mandates equal pay for men and women in similar roles at the same company, and it's enforced by the EEOC. Then you have your Family Medical Leave Act. So we're going to spend a little bit of time on here. So the FMLA entitles eligible employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. So to break that down, your employers are allowed to take time off as if they were working in the same role, and they will come back to either that role or similar. And so there's a few things that will be provided in that. So 12 work weeks of leave are provided for special occasions such as childbirth, care for serious health conditions of the employee's spouse, child, or parent. And in addition, 26 weeks of leave during a 12-month period to care for service members with serious injuries. So this means that the FMLA is all-encompassing. There's not just two things that are included in the FMLA. So there's a lot of circumstances that can be covered in this 12 weeks of unpaid time. So please reach out to us if you have any questions. If your team member is going through something specific and you don't know if it applies for FMLA, this is something that we as a company take extremely serious. So let's make sure that we're providing them this benefit and that we're not going to, deny anyone of their rights. So if you have any questions or you need any further knowledge on this topic, just let us know. And then the last one we have here is Employment Retirement Income Security Act. So this sets the minimum standards for most voluntary established retirement and health plans and private industry to protect individuals in these plans. One thing that's super important when we think about this Retirement Income Security Act is we provide a current retirement plan here at the company. It's a 3% match after you've been with the company for 1 year, and you're vested after 3 years, meaning you can take the money that we provide as well as your money and you will be vested, and you will not need to work with the company anymore to apply that to your own, personal income. If you leave before 3 years, you will not get any of the dollars that we contributed on your behalf. This is important because this act is something that enforces or requires us to provide maintenance and information to our employees, meaning we have to provide them with a way so that they can access the information. We have to provide them with tax documents on this information. These are things that we need to provide them. We need to inform them if they are, leaving the company, how do they get those funds? If they are retiring tomorrow, how would they get those funds? We need to give them a website that's up and working. So this is something that we're required to do, and since we are in a corporate office, you may encounter this with some of your new employees as they get set up, so we have to provide this to them. Then next, we talk about pay. I think how we come about with our pay rate and our pay scale is extremely important because it impacts a person's career and it has a long-term impact. So the first thing we'll talk about is benchmarking. So that's basically comparing our practices against those in competition, and it'll allow us to keep a competitive pulse on the market. This is something that, our employees or your future reports are doing before they even get to the company. They want to know who has a role similar, how much are they paying, and how do the benefits stack up. The same way they're doing it, we're doing it on our end. We're not only doing it so we can uphold a brand, but we also want to ensure that we're paying people properly and fairly so that they can be enticed to come to work and to stay with the company because they know that they're being valued. So that's a way that you can uphold, equity within pay. And then rate ranges. This goes back to the example I talked about with the same name with different pay rate. So different pay rates can be justified within the same role. Please consider some of these benchmarkings against our competitors and work with us to really make sure that we're giving people the right rate for the value that they're bringing to the company. So there are certain circumstances where two employees have the same title and it doesn't warrant the same pay. We want that to be strictly on the role and not because of any other factors. So please reach out to us when we're talking about rate ranges here. And then overtime pay. So there's been recent changes under the Biden administration. So this in overall refers to the payment for hours over 40 per week. So exempt employees include paid salary, and then the salary over a minimum threshold, and premium executives, administratives, and professionals. So these people are not allowed to get overtime, but for those who are impacted by overtime pay, starting after June 1, which is most of your reports, if you're a new manager, we have the new wave of hires starting after June 1. So those employees making less than around $44,000 a year, they'll be eligible for overtime. And after January 1st, 2025, employees making under around $57,000 a year will be eligible for overtime. This pay rate, this this pay qualifier should stay intact until 2027. So let's just look out for any updates from the government to see if this updates. But as of right now, those are the only two increases that we know. So we work in corporate and most people are salaried, so we don't necessarily handle overtime pay cases very often, but should we, this is the guidance that we have currently, so we will adhere to this, and we'd like you to keep this in mind. So why does this matter? So not only is it ethical to pay people fairly, but there are rules and laws in effect to ensure that companies take the right measures around compensation and benefits. So discrimination, pay disparity, and unfair wages, they can negatively impact the business and even result in strikes. And to avoid this, we want you to reach out to us if you have any questions, because we don't want to interrupt your business as much as we don't want you all to be unhappy in the management role either. So, compensation is extremely important. It's a large part of our day-to-day. So we want to make sure that, we know what these things are, and that way we can apply our knowledge. And so we have, why are these important? Again, we've already discussed it, but I wanted to throw this back up. So thank you all for sticking around with me. And again, I want to talk about why they're important. So, they're set in place to protect not only the company, but the employees. Because regardless of if you're a manager, if you're a people manager or not, we all have a stake within the company, and we want to make sure that it's a safe environment and that we feel we're getting out what we put in when it comes to value, right? So we want to be respectful of people's time. And hopefully you've been able to understand what these are and how they will help you. And so, protect your brand, protect our brand, keep employee morale up, and let's avoid that competitive disadvantage. And so what I'll do now is, if you don't have time to go through the appendix, that's fine. I will send it out, but I'm still going to run through it. And then if you have any questions, feel free to reach out to us. So in the appendix, we have the contractual agreements and mandatory arbitration. So this is mandatory arbitration and severance agreements. So the purpose is, these are law binding contractual agreements between the employers and employees regarding several topics. And the first two we'll cover is mandatory arbitration agreement. So this requires parties to use a third party outside of court to decide on issues based on the hearing that the employer and employee must adhere to. So while we do require our employees to sign these agreements within the first 30 days of their employment, we need to be cautious of all issues that have been we need to be cautious of all issues, as there have been several clauses to the mandatory arbitration agreement, and there are more ongoing cases about this. So we want to be sure that we're adhering to all of the laws, regardless of what we put down in the agreement for a non-disclosure or anything of that nature, because employees have rights, and we want to make sure we're not negatively impacting them with anything that we do. So, for example, sexual harassment has been excluded from protection for the company, regardless of any contractual agreement. So, even if we put that we have to go through mandatory arbitration and the agreement is settled, and the employee is satisfied, they can still go file a case based off of this new law. So let's just make sure that we are being cognizant of how we treat people and their time. And then we have the severance agreement. So this is a legal document specifying conditions of termination. It's bound when employees and management provide a signature of approval. So basically, HR on my end, we provide them to our salaried employees, and we manage a template that we constantly update. So you can come to us if you need an updated template. But in general, these documents, they protect us from employees taking legal action after the termination. So some of the things that are normally included in there are the pay. So here at our company, we have a base pay once we do layoffs of 2 months. So everyone gets 2 months pay, and then for each year you get another month. So example is, if someone worked at the company for 5 years, they would get 2 months pay base plus 5 additional months pay. So that'd be 7 months total. If someone was only working at the company for less than a month, they would get 2 months pay base, 0 months added on to their total, because they have not made a year yet. So if we are going to, have mass layoffs, we'll talk about that on the labor relations, but we will work with you to make sure we're providing the employees with a continuous flow of information, and that will include a severance agreement that they will then pay, and we can uphold that in a court of law if there are any questions about the termination. And then the second one is the second piece of the appendix, and the last piece is labor relations related law. So the purpose is to provide and protect employees' rights to representation and to unions to negotiate in good favor. So we have the Wagner Act, or the National Labor Relations Act. And so this supports employees by providing the ability to enhance working conditions and negotiate contracts through unions. So the National Labor Relations Board, they review cases between unions and management enforcing the NLRA. And the reason how this came about is there was a lot of contention between employees and unionization back in the 1900s. So it's extremely important that we are adhering to this law and we are not causing any convenience for unionization, and we are following the law and hopefully providing a safe work environment for everyone. And so you have the Taft-Hartley Act. So this revised the Wagner Act. It added in support for employees to have the right to refuse to join a union as a condition of employment. It made it unlawful for a union to dispute with another employer to pressure them into doing business with the union, and it prohibited unions from charging excessive dues or fees to employees. So this is basically, the NLRA set the ground that unions are going to be accepted under certain circumstances, and then the Taft-Hartley Act came back and kind of enforced some of the rights for people. So now employees can't be forced into a union. You know, they have a choice within their first 30 days if they would like to join the union or not. You know, unions can't charge them excessive fees so that they can be represented, and other employers cannot be negatively impacted should they decide not to have a union at their company. So that's extremely important. We don't necessarily handle union cases here, but if we do, we will adhere to these laws and, you know, take it on a case-by-case basis. And then we have WARN, which is the Worker Adjustment and Restraining Notification Act. So I talked about this on the severance agreement piece. But this is relevant for employers with 500 or more workers at one site. So we must provide 60-day notice before a layoff. And so we will work with leadership, you know, to ensure we're supporting our employees through the transition and provide you all as their managers with the resources you need to assist the impacted employees, such as, you know, the state or the local rapid response team. We'll work on those severance agreements. We will work on providing them, you know, mental health resources, any other resources that we can provide them to find a new role, to have a seamless, you know, financial transition. We want to help create that smooth transition out of the company with you as their manager. So, you know, we will adhere to the WARN Act. And last but not least, we have the Immigration Reform and Control Act. So this places the civil and criminal penalties on employers intentionally hiring undocumented immigrants or people unauthorized to work in the U.S. The one thing that I will call out here is we do thorough checks before we hire people. We do thorough checks when we do our nines. We send out tax information, so we have, you know, people's personal data. One of the things that I want to call out is, as a manager, if you ever become aware of something that the company has either missed or someone has been dishonest with us, we need you to report this. These have extremely negative implications if we do not handle them properly. So please inform us if we have missed anything or anything needs to change. And that, my friends, is the end of our presentation. So please let us know if you have any questions. You can always reach out to us on the HR website. And I will see you all soon.